In the last video, I said that in the second part of it, we talk about check forgeries and the rule for dealing with banks in that situation under the UCC. I forgot to talk about it in the last video, so I'm just going to make a brief video here to cover just this one issue. And what we're going to do is talk about one case that deals with such a fact pattern and gives us the rule from the UCC as to when a bank is liable for forged checks and when they're not. All right, so this case is about a business that does business under the name Enchantment, and they sell recreational vehicles. Their legal name is Associated Home and RV Sales, which is why that's the plaintiff named here in the case. And then this is against the defendant, which is their bank, which paid out all of these forged checks. Now, the forger is or was their bookkeeper, the person in charge of keeping track of the revenue and expense streams and writing checks for legitimate expenses on behalf of the company to other companies that Enchantment actually owed money. In addition to that, though, what she was doing was for the course of 20 months was writing checks to herself or just to cash and taking to the bank and just taking the money out directly. Now, there's going to be a question later as to whether or not the bank was negligent in doing this, whether they should have eventually whether the teller should have questioned, why does this person keep writing checks to herself? Because it's not the most sophisticated crime. Somebody else would have at least created a fake company that purported to do something for Enchantment, like cleaning services, and then every month write a check for what were supposed to be cleaning services to the name of that company, and then taking the money out from that fake company so that you're not giving evidence that you're taking all the money directly. So 20 months, over 200 checks, almost $300,000 she managed to steal. And eventually the managers discover the forgeries and they notify the bank. Now this is a lesson also in not being too trustworthy of anybody when it comes to your bottom line and checking on the books even after you've hired somebody, especially if you're the owner of the business, to check on that a little more frequently. So they want the bank to cover the losses because they said they shouldn't have been paid out in the first place, and the bank refuses, not surprisingly, to cover the loss because they say, you know, this wasn't our fault. We didn't forge the checks, and we didn't know, as her bookkeeper, we didn't know that she didn't have the right to do this. And they also note that they send monthly statements, as banks do, that include, as they're required under regulations, photocopies of all of the checks. And this is still done to this day. Now we do online banking, but if you go into your online bank account, anytime there's a check that passes through your account, there has to be an image of the check of the front and the back so that you can compare. You can see what it was written for and who signed it and what the signature looked like and so on. And that becomes an important reason for the rule we get from the UCC. Now, the trial court grants summary judgment to the bank and says, if you remember from our earlier chapters, summary judgment is appropriate when there aren't any material facts in dispute that need to be decided by a jury. So we tell the judge they simply need to make a ruling on the law and how that law applies to the otherwise undisputed material facts. And so the bank wins on that basis. The court says, we don't think there's any material facts in dispute, and we think the law rules in the bank's favor. So Enchantment appeals, and that's where we're at now. The appeals court reverses that decision and says summary judgment is not appropriate because there's still some issues of fact to be resolved, and that's because of the rule under the UCC. As to when a bank is liable only for negligence in cashing forged checks, and when they're liable, when they suffer strict liability, where, as with other forms of strict liability, it doesn't matter. We don't have to prove that you did anything wrong and that you were negligent. You were just strictly liable under these circumstances to cover the losses. So what the rule says is because banks send you these statements that show you pictures of the check and they're giving you this evidence to work with, the bank is only strictly liable in that 30-day window between those bank statements, right? So they're strictly liable for forgeries that are paid out in that window before you were able to see the images of the check. But after you've had notice in your first statement, after the forgeries have occurred, then the bank is only liable if you can prove that essentially they were negligent. After the 30-day period, the bank is liable only if the customer proved that the bank failed to exercise ordinary care in passing the forged check, and that the bank, their failure to exercise that ordinary care, substantially contributed to the loss. And so that's why the case is sent back to be decided, to have a chance at a jury trial. We know the bank is strictly liable for that first section, but now the appeals court says it needs to go back to a jury trial or a bench trial if that's what they want, and on this issue of whether the bank, after that period, failed to exercise ordinary care that substantially contributed to the loss that the plaintiff suffered. And that's why I said in the beginning, there's an issue there about this person writing checks to themselves and being pretty unsophisticated in their plot, because we might say that it would be a part of ordinary care for someone working at a bank to eventually, at least after a couple of months, wonder why this person is writing themselves so many checks and not even under a business name. So that's the rule under the UCC for forged checks and when the bank is liable.